morning. Thank you for joining us for this Contracts Update webinar. This webinar is part of the 2019 Maryland Realtors Webinar Thursday series and one of the free Maryland Realtor benefits. Today's webinar will be recorded and available on our website late next week. Our presenters this morning are Colette Massengale and myself, Jeff Bernstein, the staff attorneys for Maryland Realtors. Please feel free to submit questions during the presentation. We will attempt to answer as many questions as possible. If you think of other questions later, or we are not able to answer everyone's questions, you can contact our legal hotline at 800-888-1272, Monday, Wednesday, and Friday from 10 a.m. to 12 noon and 2 p.m. to 4 p.m., or submit online by visiting www.mdrealtor.org. Thank you, and let's begin. Colette?
Thank you, Jeff. Thank you, everybody, for joining us today. So we have our Contracts Update series here, and I will go ahead and get started. With the agenda. All right, so we're going to be covering the top 10 contracts best practices, and then we'll do a very brief contract law review, and then we'll do some frequently asked questions, which are basically some of the questions that we receive in the CE classes that we teach and on the legal hotline. And Jeff will definitely be chiming in with some scenarios that we have been seeing lately. So I'll go ahead and move forward. All right, so top 10 contracts best practices. Number one, want to check to ensure that the date of contract acceptance is filled in and accurate.
Yeah, and Colette, one of the common questions we get is, what should the parties do if the date of contract acceptance is left blank?
So if the date of contract acceptance is left blank, the best practice is to have whichever party was the last party to sign an initial to go ahead and do that. You want to make, but the key there is making sure that all parties are on the same page about what that date actually is. So when you get the confirmation in writing that all parties, whichever is the last party that signs it and dates it, they really should be the one to insert the date of contract acceptance. But really the key is making sure that that date, everybody agrees to that date. You want to have that confirmation in writing. Any other questions on that, Jeff?
No.
Okay. All right. So that's really key, making sure that that's in. And another question that we do get on that is, can the agent or broker fill in that date? And of course, again, the best practice is to have whichever party is the last named party to sign an initial to do that. Can the agent do it? Yes. But again, I want to make sure that that date is accurate, and you want to get written confirmation that all parties are on the same page as far as what that date is. Number two, we want to understand that verbal communication of acceptance of an offer constitutes delivery. So here's a common example. The buyer agent submits the written offer over to the listing agent. The listing agent passes on the offer to the seller. The seller signs and initials all places in the contract, gives it back to the listing agent. So now the listing agent has in hand a document that is signed by all parties and initialed by all parties where it needs to be. When that listing agent contacts the buyer agent, maybe they make a phone call and says, hey, we have a contract, I have the fully executed document in hand, that delivery or that communication of acceptance via that phone call constitutes delivery under Maryland law. But again, I want to reiterate that the best practice is to communicate acceptance and be transferring the fully executed document to the other party at the same time. All right, any questions on that one, Jeff?
No.
Okay, I'll go on. Number three, if the parties agree to modify the existing contract, they should do so in writing, right? So that's hopefully everybody's kind of in tune with that. As you all know, as of October 1, 2019, there is a new form, the change in terms addendum. So if, and this of course applies in situations where the parties have already executed the contract and one party wants to make a change. So in the change in terms addendum, you can change the purchase price, the settlement date, or any other aspect of the contract. And if the other party agrees to the change, the parties would sign it and date it, and that new modification would become binding on the parties.
Yeah, and Colette, we're actually getting a few questions in on the date of contract acceptance, and the real question is, what happens when the date of contract acceptance varies from the date of delivery?
The date of contract acceptance varies from the date of delivery. Well, we want to try as best we can not to have that happen, but it's really the date of contract acceptance that governs, you know, most of the actions the parties have, right? So it's, you know, home inspection contingency, financing contingency, all those contingencies move or are dependent upon the date of contract acceptance, not the date of delivery. So again, as long as all parties are on the same page as far as what the date of contract acceptance is, then those contingencies will run from the date of contract acceptance. But the best practice, of course, is to make sure that you know you're delivering acceptance at the same time, you know, on the same day, hopefully. Does that make sense?
Yeah, exactly. Yeah, exactly. So it's just really important for everyone to remember that when both parties have signed and you have an accepted contract, that you should deliver it as soon as reasonably possible to the other parties, because that's when the time frames start to run. It's right. Really a very bad practice with repercussions if you were to delay delivery and essentially screw up a party's ability to comply with the time frames.
Right. Right. So yeah, so that's the issue. I mean, you're definitely going to run into some issues if there's a discrepancy there.
Yeah, and when we're talking about delivery can be verbal again, everyone. So if an agent says they're accepting your offer, that's going to be delivery as long as they have a signed copy of the contract. Same thing if they were to say we have an executed contract. Those are both different phrases, but that can constitute delivery as long as there is a signed contract. So there's no magic words that are going to constitute delivery. It's just informing the other party that both parties have signed this contract and we're going to proceed and move forward with this contract. And then just so everybody's clear, the date of contract acceptance is in the contract. It's on page 10. It's almost the very last line of the paragraph of the contract on page 10. So this isn't a separate addendum or separate document that's going to indicate the date of contract acceptance. It's within the bodywork of the contract. So just be aware of that.
Yeah, thanks, Jeff. And then just to just reiterate, the date of contract acceptance is the date that the last named party has assigned and initialed where required in the form. So, all right, now you want to go on?
Yes.
Okay. All right, so number 4, know that if a party wants to modify an existing term of the contract but the other party does not agree, the underlying terms of that contract remain in full force and effect. So that's, I think, really kind of a key point and piggybacks on the other point number 3. But anytime, you know, at any time after the contract is formed, either party can request to modify the terms of the contract, right? But if the other party doesn't agree, the underlying terms of the contract remain in full force and effect. So, for example, let's say the settlement date was November 15th, and the buyer wants to move it forward maybe to November 20th. So they might submit the change in terms addendum saying they want to move the settlement date forward. But if the seller doesn't agree with that, then the original date is going to be in full force and effect. So that's really kind of what that's saying. Any questions on that one, Jeff?
Not yet, but I'll bring us back to it if they come up.
Okay. All right. Number 5, be mindful of the prohibition on practicing law without a license. And of course, we always have to kind of reiterate the importance of steering clear of drafting, and really what we're talking about here is drafting addenda, modifying the terms of the contract. Of course, the parties are free to modify the terms of the contract. Of course, assuming it's not something, a disclosure or something like that that's required, but they can change the terms of the contract. The best practice, of course, is to have the parties themselves make the change. And when you get into, as a licensee, an agent, or broker, drafting addenda or modifying, then you're kind of getting into that gray area, and you just don't really want to go down that road. So use the forms that are prepared for you. If a party wants to make a change, if a client wants to make a change, they can do it. You can get them to do it, put it in writing, and give it to you, or of course their attorneys can do it. That would be the best practice. We'll go on. Any questions on that one?
Not yet.
Okay. Go on to number 6. Understand that there must be an agreement on the material terms to form a valid contract. So some examples of what the material terms are: the settlement date, the names of the party, the purchase price, the description of the property, any contingencies. Those are all financing terms. So any contingencies, financing terms, those are examples of the material terms of the contract. They have to be fully spelled out, and that's really the key. Any material terms of the contract have to be fully spelled out and agreed on by the parties. A good example of that is the financing terms. So we've always said that, if the buyer puts in the interest rate TBD, to be determined, or something market rate that's not sufficiently detailed, the financing terms are material. They need to be specifically spelled out. We have said it's okay to say not to exceed X, but you want to make sure that all the material terms are spelled out. The example here says buyer's offer comes into seller with paragraph 4B of the property inspections addendum initialed. That's the Maryland REALTORS property inspections addendum. Seller strikes through the box and initials and sends a counteroffer back to the buyer. Buyer never initialed the strike through. Is there a contract? Well, paragraph 4B of the property inspections addendum, we don't have that here, clearly says that if an offer comes in and the buyer has initialed paragraph 4B, but the seller doesn't agree to that, then the seller needs to strike through 4B. They need to initial the strike through. It needs to go back to the buyer for the buyer to initial the strike through, and then we can proceed. If the buyer fails to initial the strike through, then our position is that there is not a contract. So any questions on that one, Jeff?
Yeah. What are some other examples of the material terms of the contract?
So I said the names of the parties is one example, the purchase price, the financing terms, the description of the property, any contingencies. Does that make sense?
Yeah, it does. I think just they wanted a repeat, so we're good to go.
Okay, so we'll go on. Number 7, contracts for the sale of property must comply with the statute of frauds. And basically, what does that mean? It needs to be in writing and signed off on by all parties in order to satisfy the statute of frauds. So hopefully that's something that everybody is on the same page about. Go on. Number 8, recognize that the failure to remove a contingency is not a default under the contract, right? And that's, of course, assuming both parties or whichever party has done everything that they're obligated to do under the contract. So, for example, if the contract is contingent upon financing and the buyer does their written application, they provide all the documentation to the lender, and the lender says, for whatever reason, there's an issue, the buyer's not going to be approved. The buyer's done everything they're supposed to do under the buyer responsibility provision and under the financing contingency. They can, once they get that notification from the lender that their financing has been denied, they can submit a notice of termination with a denial letter from the lender. They're not in default. They simply weren't able to remove the contingency. So any other kind of questions on that coming in?
No, not at the moment.
Okay, and the difference there, a breach of the contract is where a party is obligated to do something and they fail to do it. So that's the difference. So the breach being something that the party is obligated to do that they fail to do. A contingency is saying this has to happen before the contract can proceed, but if it can't happen, even though the party's done everything they're supposed to do, they just weren't able to remove the contingency.
Yeah, so one of the common questions that's coming in, Colette, is that what's an example of the seller side default or breach?
Seller side default? One that immediately came to mind is, let's say, and this happens on occasion, the seller decides that they don't want to sell the property anymore, and they don't show up for settlement. That would be considered a default, and that would enable the buyer under the time is of the essence provision to submit a notice terminating the contract, and they could pursue damages from the seller for failing to show up at settlement and convey the property.
Yeah, and another common example would be in respect to home repairs from the inspection report. When a seller agrees to make certain repairs and then fails to do that by the time frame agreed to by the parties or by settlement, that could also constitute default.
Yeah, that would be default. And if the parties are using the Maryland Realtors contract, then we usually say, what happens next if there is a default, the parties can't resolve the dispute, then we tell them about mediation, because the parties, if they use Maryland Realtors contract, they are obligated to mediate any disputes that arise out of the transaction before filing a claim. So you can find out information about mediation on our website. You can call the legal hotline, but that would be the next step if there is a dispute that arises from a default. Any other questions on that one?
No.
So go on. Number 9, the parties don't have to create a separate agreement to negotiate the contract electronically. So that's our position based on the Maryland Uniform Electronic Transactions Act, that the parties' actions are sufficient to proceed with negotiating the contract electronically. You don't need a separate written agreement to do that. Any questions on that one?
No.
Okay. All right, we'll go on. And then finally, number 10, remember that if something is said verbally in an email or mentioned in the MLS and the client wants it to be binding on the parties, it should absolutely be included in the contract. And that also brings me to the point in the Maryland Realtors contract, paragraph 59 on page 10 says that the contract, any addenda, contain the final and entire agreement between the parties. So if the seller is offering a home warranty, whatever the case may be, new countertops, whatever, you want to make sure that those items are in the contract. It could be in the inclusions section of the contract, so make sure that it is in the body of the contract. Otherwise, it's not going to be binding on the parties. Any questions coming in on that? No?
Not at the moment.
Okay. All right. So I'll go on to a real quick review of contract law. All right. So we get this question all the time. Offers and counteroffers. Just a reminder, all offers and counteroffers must be presented in full. We have the reference here to COMAR, the Code of Maryland Regulation 09-110202, paragraph H. Presentation of offers. What does it say? A licensee shall present all written offers or counteroffers received by the licensee to the client as required under the Brokers Act, which is contained in the Business Occupations and Professions article. All right, so what's the key here? Unless otherwise specified in the brokerage agreement, all written offers and counteroffers have to be presented to the client. And the fairly new part of this regulation is 2A and B. So all offers and counteroffers have to be presented to the client in full and in hard copy or electronic format. So that's Code of Maryland Regulation 09-11020202, which was updated around 2016, 2015. All right, any questions on that one?
They're probably going to be coming in, so
I will say NAR, National Association of Realtors Standard of Practice 1-7 was updated. So if the cooperating broker requested, you want to provide affirmation that the offer was presented or notification under Standard of Practice 1-7. But again, it's really making sure that the offer is presented, the counteroffer is presented in full. But I just wanted to alert you to the update to SOP 1-7.
Yeah, so the questions coming in really are about that, or how do we ensure our offers have actually been presented? What's the recourse if they fail to respond to an offer? And then even, can an unlicensed assistant present an offer on behalf of the agent? So basically, as their assistant, send the offer to the other party.
Well, it's interesting because we're working on it, and this may come to be in October of 2020. We are coming up with a form that the listing broker can provide to the cooperating broker saying, yes, the offer was presented, or no, it wasn't. But you could reach out to if you're the buyer agent and you're not sure if the offer was presented, you reach out to the listing agent via email to get that confirmation. If it's a situation where one of the agent's broker is not responsive, just be aware that the parties can communicate with each other directly. Licensees cannot, but the parties can. So if a buyer doesn't believe their offer was presented and the listing agent or listing broker is not being responsive, then the buyer could call the seller directly. So those are just some of the ways to ensure that or to check to confirm that the offer was presented. But there may be, coming down the pike, a new form premised on Standard Practice 1-7 that will allow, the cooperating broker to get confirmation that the offer was presented. But that's not in play just yet. That's in the process and has to go through. But that may be the case in October 2020.
Yeah, and one of the common scenarios that comes up with this is, what's an agent to do when there's a missing initial or a missing signature on one page of the 59 pages that constitute the entire contract? Should they send the entire contract back, or just the one page that needs the signature?
If it's missing, I mean, what's the regulation saying? Presenting all offers and present all offers and counter offers to the client. If it's tricky because you want to say, well, if it's just missing an initial on page 2 of the contract, then just send that back. But if there's any changes that crop up, I think the safest thing to do is to send the offer, counter offer back over and get that initial corrected. What are your thoughts on that, Jeff?
Yeah, I agree. I don't think there's anything from the Real Estate Commission to suggest that they're going to be lenient with the interpretation of this regulation. So the best practice, the safest practice from a risk management standpoint, is to send the entire document back. It's not too much of an issue with electronic delivery to send the entire document back with a notation that a signature or initial is missing in one place, which I think is part of the reason why the regulation is in place the way it is, that they want everything to be done in full. That way everybody can see their entire document at once when they are signing or initialing or making any changes. Yeah.
Yes, I think that's the safest thing to do. Might be a little bit laborious, but I think it's the safest thing to do and keeps you in compliance with COMAR 09110202. All right, so I'll go on. All right. Yes. So rejection of offer, counteroffer, what's the best practice? If you're going to seller counters the offer, buyer never responds. All right, and this is assuming the offer's been presented in writing, right? So buyer presents the offer, seller counters the offer, buyer never responds. A new offer comes in. Seller wants to accept it. Is it okay for the listing agent to call the buyer and explain that they have been directed by seller to revoke the counteroffer? So the best practice, if seller wants to revoke their counteroffer, is to do that in writing. Seller would submit in writing that they are revoking their counteroffer, and then if a new offer comes in after they have revoked their counteroffer to buyer one in writing, then they can proceed to entertain a second offer from buyer number two. Any thoughts on that, Jeff?
No, I think you're spot on with that.
Okay. All right, let's go on. Validity of contracts. This is a contract is void when it has no legal force in effect because one of the essential elements is missing. Contract to kill. Well, hopefully nobody's doing that. And one party is mentally incompetent. Contract is voidable. I would say this, when it comes to void versus voidable, most of the scenarios that we see in these transactions have to do with the contract becoming voidable. It's usually not something, there isn't something usually that happens that automatically voids the contract. So for example, I'll use the financing contingency again because that's an easy one. If the buyer is not able to get the financing specified in the contract, then the contract is actually voidable. It's not automatically void. So what would happen, the buyer would send over the notice. They could do a unilateral notice of termination with the denial letter accompanying it, and that would effectively terminate the contract. Or for example, if it's a short sale and the short sale wasn't approved by the lender, if you're using the Maryland Realtor short sale addendum, the contract is voidable, not automatically void. So in most instances in these transactions, it's going to be a situation where the contract is voidable, which means that the party, one or the other party, is going to actually have to take steps to terminate the contract. So the hypothetical here, buyer John Smith submits an offer that is accepted by the seller. After the fact, the parties realize the contract states the buyer is John's, so the spelling is off. Is the contract valid, void, or voidable? But again, I think we get the point there, the difference between void and voidable. Any questions on that one, Jeff?
Not yet.
Okay. Contract termination. And this is a good opportunity to talk just very briefly about the changes to the forms dealing with contract termination. So we know that there are two options generally. There's parties mutually agreeing to terminate the contract. And that's obviously, I think, that if you can get the parties to agree in writing to terminate the contract, that really does give it a sense of finality. There's also the ability, depending on what the contract says or what the law says, for a party to unilaterally terminate the contract. All right, and of course, time is the essence provision on page 1 may play in there. There are also concerns about the earnest money deposit, so we'll talk about that in just a second. Let me just take you through the revisions to the forms that allow the parties to terminate. So we have the mutual release of obligation under contract of sale. You all remember that this used to look like this on the top, right, and then on the bottom was the mutual release of obligation. Well, the mutual release deposit agreement was on the old version of the form. The Statewide Forms Committee elected to make these standalone forms. Much of the language remains the same. There is a reminder there in the mutual release of obligation under contract for buyer and seller to use the release deposit agreement to facilitate disbursement of the deposit. So you don't want to forget about the deposit now that we have these standalone forms. So that's really just the key to remember, that there is a separate release deposit agreement now. You got to deal with the deposit and also deal with the contract. You don't want to forget one or the other. So you've got the mutual release of obligation under contract of sale. That's now a standalone form with a note to alert buyer and seller that they can use the release of deposit agreement to deal with the deposit. There's also the new standalone, or revised, I should say, standalone unilateral notice of termination. So again, if the contract or the law allows a party to terminate the contract, they can use the unilateral notice of termination to do so. And you'll note, because we get questions about this a lot, that there's no place for the other party to sign. So let's say the contract permits the buyer to, maybe it's a contract contingent on a home inspection, and the seller has elected not to make all the repairs that the buyer has requested. One of the options that the buyer has is to terminate the contract. So they can use the unilateral notice of termination of the contract to do that. They would sign it and date it and send it over to the other party. The other party, there's no space for the other party to sign it. So once that unilateral notice of termination is submitted to the other party, then the contract is effectively terminated. And that's, of course, assuming that the party is within their right to do that. Are there any questions on these termination at all, Jeff? No?
Just that, as it relates to a deposit, they don't have to use the release of deposit agreement if they want to use a different form to mutually agree, or do it via email and have mutual agreement presented that way.
I would say the best practice is to go ahead and use the release of deposit agreement, because we know that it complies, with the statute, if the broker is holding it. But could a different version of a release of deposit agreement form be signed? Yes. Doesn't have to be the Maryland Realtors version, but that form is a good one to use. Any other questions on that one?
There are a lot. One question is, can the unilateral notice of termination be used to terminate a contract based on HOA or condo docs? That's come up a few times in the questions here.
Yes. So we know the Condo HOA Act, if the buyer doesn't have the disclosures and there's something at the time that the contract is formed, and they get them after the contract is formed, and there's something in those disclosures that they are not happy with, the HOA Act and the Condo Act do give the buyer the right to terminate the contract. So they could use the unilateral notice of termination to effectuate that termination. And they would have to deal with the deposit as well. Hopefully, the parties would be in agreement about who gets the deposit, and they would execute the release of deposit agreement. But yes, the unilateral notice of termination could be used in a situation where the buyer is terminating under the HOA or the Condo Act. Any other questions under that one?
Not at the moment, but I'm sure they'll keep coming in. So if we need to, I'll bring the conversation back to that.
Okay. All right. So I'll go on. So yes. So the release of deposit agreement, now a standalone agreement, and essentially this form complies with the statute. Good form to use. Buyer and seller acknowledge and agree that the deposit shall be distributed in accordance with the deposit paragraph of the contract. It spells out who's going to get the deposit and how much. When the buyer and seller sign it, then that would effectively make it a valid release of deposit agreement. All right. So again, just to reiterate that these forms are all now standalone forms, and you don't want to forget about the deposit if the parties have agreed to terminate the contract. You just need to remember to deal with the deposit as well. All right. So I'll go on. What are the remedies for breach of contract? So essentially, there are two. There is potential for whichever party is in breach or whichever party is not, or whichever party did not breach the contract could pursue damages, contract damages, and there's different types of damages that the non-defaulting party could pursue. There's also an equitable remedy, which I'm sure you all are familiar with, specific performance. But the thing to remember about breach of contract and where you go from there is the party's obligation to mediate any disputes before filing any type of legal claim. So there's contract damages, there's specific performance, but before we go there, the parties have to at least attempt to mediate the dispute before they go in that direction. Any questions on that one?
No.
Okay. All right, deposits. If held by the broker, what are the options specified in the Brokers Act? So there are essentially three. We've got the release of deposit agreement. So this is all spelled out in Section 17-505 of the Brokers Act. All right, so what do we do? If the broker is holding the deposit, what are the options? So hopefully the parties are in agreement on who gets the deposit if the transaction doesn't settle. The broker would provide the release of deposit agreement to the parties. They would agree on who gets the deposit, sign it, date it, and that would effectively deal with the deposit. If there is a dispute or an issue, the broker has a few other options that they can elect to do. One of them is a 30-day letter. There is a sample 30-day letter in the broker policy manual template, which is available on Maryland Realtors website on page 3. So if a broker chooses to, they can send a 30-day letter, send it out to both parties by regular mail, certified mail, return receipt requested. If the broker doesn't get a written protest from either party within 30 days of sending out the letter, they can go ahead and disperse it in the manner they said they would in the letter. If they do get a written protest, then they cannot disperse it. So the 30-day letter is one option. The broker can also, if they're holding the deposit, file an interpleader. That would usually take, involve an attorney in the matter. So the attorney would file the interpleader. Basically, what you're doing is depositing the money into the court registry and just basically having the parties fight it out. The other option that the broker has, if they're holding it, is just to simply keep it in the trust account until such a time as there is an agreement between the parties or perhaps a court order. So those are the options for the broker. Are title companies held to the same standard as brokers? Not exactly, but there is a new law. I'm sure you all are familiar. As of October 1, 2019, if somebody other than a real estate licensed broker is going to be holding the deposit, then that escrow agent and the parties must execute an escrow agreement that complies with that escrow agent new law. And just to give you an idea, the escrow agreement that Maryland Realtors prepared and posted last year does comply with this new law. So if somebody other than the broker is going to be holding the deposit, which would include a title company, then just be mindful that the parties are obligated, in that escrow agent and the parties must enter into an escrow agreement. And so, again, the Maryland Realtors escrow agreement does satisfy the requirements of the new law. If held by somebody other than the broker, what is the best practice? And again, well, now the best practice is to comply with the law, right, which is to have the buyer, seller, and escrow agent execute an escrow agreement. Any questions on that one, Jeff?
The questions are really about mediation and where can people find mediators and the cost of mediation, and also how long does that requirement last?
All right, so mediation, great information about mediation can be found on Maryland Realtors website. If you go to the legal tab and then you go to dispute resolution, you'll see a box that says mediation. You can open that up. There's all manner of information on the organization that we use. The name of the company is OM Services. Their link is there. There's information about how mediation works a little bit. There is a phone number that you can call to get additional information if the parties need to go in that direction. What was the other question? The cost. My understanding is that the cost ranges from between $350 and $500, I think, to cover the cost of the mediator and the mediation services. So that's information that you can find out too by contacting OM Services. But my understanding is the range is between $300 and $500 or $600 for the cost. And then how long does the obligation to mediate stay in effect? It's within 1 year of settlement, excuse me, or when settlement should have occurred. So if settlement was today, November 14th, if there's a dispute that arises between now and November 14th of 2020, the parties would be obligated to mediate that dispute. So it's within a year of when settlement occurred or should have occurred. Any other questions about that?
What about, is there The questions come in from several people. Is there a statute of limitations on filing a mediation request? For instance, is it okay for a party to wait 3 months before initiating that process?
Well, as long as they're within that year time frame, we don't really call it a statute of limitations because it's not like a legal claim per se. So, for example, we say, how much time do you have to file a breach of contract case? Well, there is a statute of limitation for that because that's a type of legal claim, and you've got 3 years. A buyer or seller has 3 years to file a breach of contract claim. On the other hand, mediation is something that the parties are obligated to do under the contract, right? So there's a difference. And there's no time frame on, well, like I said, it's 1 year. So if there is a dispute that arises, let's say settlement was today or is today, and there's a dispute that arises tomorrow, the buyer, doesn't initiate it until December, they're still within that window, so they could still proceed with initiating mediation even though they didn't contact the mediator the day after the dispute arose. Does that make sense?
Yeah, I think it makes sense. It's a little bit of clarity for everyone.
Okay. All right. So any other questions on that before we go into FAQs?
I guess if mediation is the result of someone terminating the contract, but there is pending mediation, is the seller allowed to put the house back on the market?
I see. So there is so if I'm reading that correctly, there is a dispute, but seller wants to proceed. Well, it depends on what the dispute is. Let's say it's over the deposit. Let's say the parties are just disputing the deposit. If the seller is the non-defaulting party, and let's say they send over a unilateral notice of termination, they're within the right to do that. They could send over the unilateral notice of termination. Once they do that, they could put the property back on the market and deal with the deposit dispute, as it goes through the process, if that makes sense.
It does to me, but if the questions keep coming in, we may have to come back and clarify, but I think we're good for now.
Okay. All right. So let's go on with some FAQs. When should the parties include the first-time Maryland home buyer addendum? So even though this provision has been in the contract for a good bit of time, it's still one of the top questions that we get. So basically, the key with the first-time Maryland home buyer is to pay attention to that expressly agreed statement. So I read to you, you've got there in front of you paragraph B of the Maryland Realtors contract. It says, under section 14-104C, the real property article, the entire amount, liquidation, local transfer tax, shall be paid by the seller of the property that is sold to a first-time Maryland home buyer unless there's an express agreement. So that's a statement of the law. Under section 14-104C, the seller pays unless there's an express agreement. Again, that's a statement of the law under 14-104C. That second sentence that I'm about to read under liquidation local transfer tax, that is the express agreement contemplated. What does it say? If the buyer is a first-time Maryland home buyer, buyer and seller expressly agree. So we have the express agreement that the parties are going to split in the body of the contract. So if the parties are going to split transfer liquidation tax or liquidation local transfer tax, we don't need the first-time Maryland home buyer. In other words, the only time you really need the first-time Maryland home buyer is if the parties are not going to split these costs. Does that make sense?
It does to me, but I'm sure we'll have some questions.
All right.
Some
So
questions
just
coming
remember,
in. That's a frequently asked question with
yes, it is.
first-time home buyers.
It is. And I think hopefully the way I've explained it, where the first sentence under paragraph B is the statement of the law saying the seller pays unless there's an express agreement. the second sentence that begins with the recordation local transfer tax section, that is the express agreement that the parties are actually going to split. You don't need the first-time Maryland home buyer unless the parties are not going to split recordation local transfer tax. All right, so we'll go on. When using Maryland Realtors as-is addendum, what is the best practice if buyer wants all personal items removed, right? So it says in the as-is addendum, the property is sold in as-is condition as of the date of contract acceptance. Seller agrees to comply with Section 10-702. The parties agree that all paragraphs in the contract pertaining to property condition and wood-destroying insects are hereby deleted from the contract. So question was, if the buyer wants all personal items removed, then they can clarify that in the as-is addendum. Because remember, with the language, the way it's written, that property condition provision of the contract, which talks about broom clean and so forth, is deleted from the contract. So, does that make sense?
Yeah, so I think one of the common questions is, what does as-is actually mean? So what does that mean for a seller's responsibilities as it pertains to property condition?
So as is and seller responsibility. And again, this is specific to Maryland Realtors as is addendum. But the key to remember with the as is addendum is that it's that first sentence. The property is sold in as is condition as of the date of contract acceptance. So there is a point there at which, or a turning point. So what does that mean? So let's say on the date of contract acceptance, the roof is fine, there's no issue with it. And let's say 2 days after the date of contract acceptance, something happens, there's a storm, the roof is damaged. The seller is going to have to put the roof in the same condition it was in on the date of contract acceptance. So there's a floor there. It's as is as of the date of contract acceptance. If things go wrong and the property is damaged after the date of contract acceptance, then the seller has agreed to put the property back in the condition it was in on the date of contract acceptance. Does that make sense?
Yeah, and I think that's a great example of it. One of the other common questions that we have is, because the property condition paragraph with it being broom clean is deleted, what happens when personal property is left that wasn't there on the date of contract acceptance?
So personal property.
So in other words, yeah, to clarify that, on the date of contract acceptance, there was no personal property in the home, there was no junk or trash or debris, but then you get to the walkthrough 2 days before settlement, and there is truckfuls of debris or personal property or what some would call junk. Whose responsibility is it to remove those items from the property?
I'd say the buyer has a pretty strong argument that the seller needs to get that stuff off the property because it wasn't there on the date of contract acceptance. What are your thoughts?
I completely agree. I think when it says as is, as of the date of contract acceptance, the seller has the responsibility to give to the buyer the home as it was on that date. So if there was no debris in the home, there should not be any debris in the home on the date of settlement. But if, and vice versa, if there was debris and personal property on the date of contract acceptance, the seller is not going to be responsible to remove that on settlement as long as it is the same personal property and debris.
Yeah, so it's substantially the same condition as existed on the date of contract acceptance. That is the key. Any other questions on the as-is addendum?
I think in the example with the roof, if the seller repairs it, does the buyer have a right to get out of the contract if it wasn't repaired up to the buyer's standard? Is there any leeway there for a buyer to get out of the contract? It needs to be put back in the condition it was in on the date of contract acceptance. Substantially the same condition. If it is not, then that's an issue that the buyer can pursue. But again, I think it goes back to substantially the same condition as existed on the date of contract acceptance. Okay, I agree. So I think that's all the questions that are coming in.
All right, we'll
moment.
go on. Paragraph 12. If paragraph 12 says inspections attached and property is sold as is with inspections, does it still need to be signed? So we've talked about this, and if it's a situation where the parties are using the as-is addendum with inspections, then we say go ahead and have the buyer initial that. The as-is addendum was created after, obviously, paragraph 12 in the contract. So it's a little bit awkward, but when we've discussed it, we've said, have the buyer go ahead and initial inspection since they have the ability to have inspections under the as-is addendum, paragraph B, if that's the case. All right. Any thoughts on that, Jeff?
No, I'm just going through some of the questions that are coming in, and it looks like we're addressing most of them. So good work.
Okay, great. We'll go on. Does a conditional loan commitment, actually just got this question the other day, does a conditional loan commitment satisfy the financing commitment portion of paragraph 10 of the contract of sale? So the answer to the question is yes. If the commitment, if it says it's a commitment, even if it has, 25 conditions, then it satisfies the definition of commitment under paragraph 10. We've gotten this question a lot. I can say the Statewide Forms Committee some years ago had lenders come in to try to, clarify this whole concept of commitment. The Statewide Forms Committee has tried in a number of different occasions to clarify the language of paragraph 10, but at the end of the day, it kind of comes back to this language. So the answer to the question is yes, if it's conditional loan commitment, it does satisfy the financing commitment portion of paragraph 10. Okay. So I'm going to go on. Any questions on that one, Jeff?
No, I think we can move on.
Okay. Maryland Realtors Property Inspections Addendum and a local board addendum of clauses with a home inspection provision are both included in a contract of sale. Each addendum provides a different time frame for inspections. Which time frame governs? So this is a sticky wicket, right? You want to avoid this situation at all costs if you can, and that's why it's really important to carefully review the addenda of clauses, the local board forms, just to make sure that the parties aren't including an addendum, let's say a Maryland Realtors Property Inspections Addendum, and also initialing a property inspections provision in a local board addendum, because what you end up with is an internal inconsistency, and in some instances it's difficult to determine which addendum is going to govern. I take you back to the as-is addendum. You'll see the language of the first, at the top there, it says the following provisions are included in and supersede any conflicting language in the contract. Well, if one of the addenda has some language like that in it, then perhaps you might be okay, but if it doesn't, then it's going to be difficult to determine which addendum is controlling. So really be careful about, go over with the client, with your client, what the local board addenda say, so that you make sure that you're not including addenda that conflict with what the parties, or what's contained, I should say, in the local board addenda. Because you want to, but basically what ends up happening is call the legal hotline, we have the discussion, and a lot of times that language that says that, this addendum supersedes, it'll say that in the local board addenda as well. So this really kind of gets you into a sticky wicket area that you want to avoid by carefully reviewing the forms and the local board addenda. Any questions on that one?
No, but we do have an interesting question that ties a couple of the concepts we've talked about with the financing, commitment, and creating a voidable contract. So is there a requirement that a buyer has to provide a commitment letter to the seller? And if they don't, does that contract then become voidable? So it's just combining a couple of the things that we've talked about.
Go back to the Financing. There's nothing. If the buyer agrees to make a written application for financing, as herein described, it doesn't say anything about giving it to a copy of it to the seller. What are your thoughts on that?
Yeah, no, I agree. The paragraph doesn't require a buyer to provide the seller with a copy of their written financing commitment.
It doesn't say that.
So, but it is a contingency. So the contract can become voidable if the buyer doesn't fulfill that obligation.
Correct.
I think the best practice for buyers would be to provide a seller evidence of that written commitment to show that the contingency has been lifted. Or if a seller requests, because you're at that time, at that deadline or approaching it, to inform the seller. Because you want to make sure you're on the same page throughout, the process of the contract. So it may not be required, but it may be the best practice to inform a seller that you've received it.
Yes. Yeah. Yeah. All right. All right. So shall we go on?
I think we shall.
Okay. All right. So that's the property inspections addendum. What is buyer's remedy if the seller agreed in writing to fix something from the home inspection and then fails to do so and settlement has already occurred? So we go back to the property inspections addendum. Seller agrees to complete repairs and provide receipts in sufficient time for buyer to inspect prior to settlement. Buyer shall have the right to inspect the property. And also, what does it say? The seller will perform in a good and workmanlike manner any and all repairs and corrective actions. So if the seller has failed to do this and settlement has already occurred, then the buyer can initiate mediation and see if because the seller basically breached the contract. If they're not able to resolve the dispute, then the buyer can initiate mediation, and hopefully with the mediator's assistance, that might facilitate an agreement, and hopefully the seller might be amenable to making the repair or doing what they need to do, doing whatever corrective action they need to do. So that would take us down the mediation road.
Yeah, I think a question that I'm going to anticipate coming in, because there's a little bit of a delay, is what can a buyer do to bind a seller to make the agreed upon repairs after settlement? So they don't want to take the chance that the repairs aren't done by settlement and settle and then have to go through mediation. So is there a method that a buyer can take to bind a seller to those repairs even through settlement?
Well, there's escrow. There's an escrow agreement. I mean, the parties can always enter into an agreement where the seller says they're going to do whatever repairs need to be done in a good and workmanlike manner. There can be escrow held, so there are ways to deal with that. But that's, definitely something that the parties can negotiate.
Yeah, and then, along with the question that just flooded the inbox was, are sellers required to use licensed contractors for repairs just because a buyer asks? Is there anything that requires a licensed contractor per se?
Well, if the item that the buyer is requesting be repaired is something that needs to be done by somebody who's licensed, then somebody who's licensed needs to do it. I mean, a lot of the stuff, a lot of the repairs, well, it depends on what the repair request is. But again, if it's, electrical or plumbing or what have you, then it's a very good chance that it will need to be done by somebody who is licensed. And if you look at the property inspections notice, it does say some repairs, or it's got language that says something like the repairs may need to be done by somebody who's licensed. So it depends on what the repair is, but I would say in a good many instances, it's going to be a repair that needs to be done by somebody licensed. It's not always the case, but it is in a good many of cases. Your thoughts on that?
Yeah, and then no, I think that's spot on. That's exactly right. And just a reminder, when a licensee is going to recommend a repairman to a client, they need to verify the repairman's contractor status or their license status to make sure that they are licensed. There is a requirement for that.
Right. So, yes. So if in the provision of real estate brokerage services, you as a licensee recommend a home improvement contractor, then yes, under the law, you have to verify that that person that home improvement contractor that you are referring, or 3 or 4 of them, or whatever the case may be, that they are in fact licensed, they have a current valid license. So yes, that is a requirement.
Yeah,
Any other questions on that?
Questions coming in is that, does a buyer have a strict right to re-inspect any repairs prior to a walkthrough? That's coming from a few members.
Well, you want to always follow the terms of the contract or the addenda, right? So the parties use the Maryland Realtors Property Inspections Addendum. Paragraph 5 says, seller agrees to complete repairs and provide receipts in sufficient time for buyer to inspect prior to settlement. Okay, that's the language. Buyer shall have the right to inspect the property upon completion of repairs or corrective action by seller to confirm that seller has performed in a good and workmanlike manner all of the repairs and corrective action which seller agreed to perform. So a lot of the questions you not always, but in a lot of instances, you want to go back to what governs that issue. So if it's pertaining to inspections, then you want to always be looking at and trying to find your answer in the property inspections addendum, because that's the addendum, that's the document that governs the party's rights and obligations. So it says that the buyer can do repair prior to settlement. So they have the right to do that.
Yeah, and I think just point of clarification is that when we're talking about a contractor being licensed by the Home Improvement Commission, we're talking about them having a valid Maryland license. We're not talking about contractors who may be licensed in another state but willing to do the work in Maryland. So just a point of clarification that would be the best practice, to have somebody licensed in Maryland do the work.
Yeah. So yes, the Maryland Home Improvement. Yes. Yes.
And the reason for that is the protection it affords your clients because the Home Improvement Commission has their own guarantee fund and their own way to regulate the actions taken by their licensees. So there's a lack of enforcement and protection if a client were to use a contractor from a license in another state. Right.
That's right. Just like with the Maryland Real Estate Commission having a guarantee fund for licensees. So that affords another layer of protection. Similar idea. All right, we're going to go forward.
Let's do it.
I think we've hit on this before. What are the parties' options if the buyer is unable to obtain financing with the time frame agreed upon by the parties? So we talked about this in the context of distinguishing between a default and a breach. If the buyer has done everything they're supposed to do under the financing provision, under the buyer responsibility provision, then they can, if they're not able to get financing, then they have the ability to submit a written notice of termination along with a denial letter from the lender terminating the contract. And again, if they have done everything they're supposed to do under that financing provision, paragraph 10, they are entitled to get the deposit back. So that's how that provision reads. Any questions on that one? We kind of belabored that one a bit.
I think we're good to go on that.
All right. Computation of days. This is a good one. What does paragraph 58 of Maryland Realtors contract say about calculating days? And this is important, I think, because if you're not using the Maryland Realtors contract, you want to make sure that you understand how the days are calculated, because they may be different. With the Maryland Realtors contract, paragraph 58 does govern. It says days shall mean consecutive calendar days, including Saturdays, Sundays, holidays, whether federal, state, local, or religious. A day shall be measured from 12 a.m. to and including 11:59 p.m. in the Eastern Time Zone. The key to remember here is, let's say the date of contract acceptance is today, and the buyer and there's a home inspection contingency. The buyer has 7 days to get all inspections done, or 14, whatever the case may be. You're going to begin the count let's say the date of contract acceptance is today, you're going to begin the count tomorrow, right? How do we know that? So for purposes of calculating days, the count of days shall begin on the day following the day upon which any act or notice is provided in the contract or any addendum or addendums of contract was required to be performed or made. So hopefully that makes sense, but it's very important to know how to calculate these days. Some of the time frames are very short. Some of the time frames are a little bit longer, but if you miss the time frame, then that could trigger the time is of the essence provision. So really, really important to be mindful of how those days are calculated.
Yeah, and I think, Colette, we talked about internal inconsistencies before earlier in the webinar, and I think that may come up again here with the computation of days and time frames. Is when we're using addenda, we want everyone to make sure that you're checking for those internal inconsistencies. So the Maryland Realtors contract says 11:59 p.m. Some of the local addenda or even brokerage addenda may state 5, 6 p.m. or 9 p.m. And you want to make sure that all of those are in alignment so that you don't have the internal inconsistencies that can create issues.
Yeah. Yeah, if at all possible, and that's another example of when you can have an internal consistency, and you just don't want to go down that road. So, it's great that we have the ability to, or the parties have the ability to conduct the transaction electronically, but you just want to make sure it can make it easy to miss things like internal inconsistencies. So that's, something to be mindful, very mindful of, that you want to try to avoid. All right, we'll go on. When can seller put the property back on the market? So it's kind of a generic question, but I think really the key there is getting to the point about the contract being terminated before it gets put back on the market. So for example, let's say the buyer failed to show up at settlement, and let's assume that they have breached the contract. That's the case. The time is of the essence provision on page 1 would kick in. The buyer could elect to terminate the contract. I'm sorry, if I said buyer, I meant seller. So the buyer fails to show up at settlement. The seller, under the time is of the essence provision, could elect to terminate the contract. What does the time is of the essence provision say on paragraph 1? Seller would send over a notice, it could be a unilateral notice terminating the contract. Once the contract is terminated, then the seller can put the property back on the market. But the key there is dealing with the contract, because what you want to avoid is a situation where the seller is selling the property to more than one person. Any questions on that?
I think we're good
Okay.
on that topic, at least. We do have an interesting question that came in earlier, and that's talking about the entire agreement and what constitutes that. So paragraph 59 talks about executing the contract and counterparts, and I think it'd be beneficial for the members to understand what that means and what does it mean to execute a contract and counterparts. And really, that's not something that's really you're going to come across very often in today's world with electronic documents and electronic signatures.
Right.
But what it means, at its core, is that each party is signing his or own physical copy of the contract, identical copies of the contract, and they're just signing their own physical copy. And then each partially executed contract is considered an original contract for evidentiary purposes. But again, it's not something that you should really encounter too often this day and age.
Right. Right. And there's got to be delivery there too. So as Jeff said, with digital transactions, it's not an issue that we see very often. So, but yeah, that is what is meant by counterparts. Did you have another question?
Yeah, we just have a couple questions coming in that are more general, but not necessarily on that topic. So
okay.
If you're ready to move on.
Sure.
lead-based paint forms. When are they needed? When is the federal one needed? And when is the Maryland one required?
All right. So lead disclosure. Now, keep in mind that local boards may have a form pertaining to lead. I will say, I can tell you what's going on with the Maryland Realtors form. There are two. There is the disclosure of information on lead-based paint hazards, which is the federal disclosure, right? That is in our forms library. The federal disclosure applies in situations of sale or lease of property constructed prior to 1978. If the property is constructed prior to 1978, the seller under federal law is required, or the landlord is required under the law to provide the disclosure to the buyer tenant. We also have the Maryland Lead Poisoning Program disclosure. Now, that form is not mandated by state law, but it is absolutely a best practice that the seller complete that and provide it to the buyer if the property is constructed prior to 1978. So again, our position is if the property is constructed prior to 1978, the seller owner is obligated to provide the federal lead disclosure, and the best practice, if it's a sales transaction, is to have the seller go ahead and complete the Maryland Lead Poisoning Program, Maryland Lead Poisoning Prevention Program disclosure along with the federal disclosure in the event that the buyer may use the property as a rental property. Does that make sense?
It does.
Okay. But the trigger is properties constructed prior to 1978. Okay. Any other questions?
Just waiting to see what else is coming in. We have a lot of individualized questions. So if you're submitting a question that has a lot of details and hasn't already been addressed, please give us a call at the legal hotline or submit it online via email by visiting our website. We have 400 attendees, so we're trying to make every effort to answer your questions, but if we can't or it requires too much detail, please give us a call with the legal hotline.
Yes, absolutely. And Jeff, thanks for mentioning the legal hotline. It is a member benefit, so please use it. The hours of operation, for those of you who may not know, it's 10 to noon and 2 to 4, where you can actually speak with one of the attorneys here, myself, Jeff, Kathleen, Mark, or so you can call us Monday, Wednesday, Friday between 10 and noon and between 2 and 4. And as Jeff said, you can also submit your question via email, and our wonderful facilitator, Sandy, will get the question to us and we will answer it that way as well. So please use the hotline. As Jeff said, if we've got 400 folks on the line, we're trying to get through all the questions, but if we don't, our apologies sincerely. Please do call the hotline and we will do our best to answer all your questions.
I think that we've addressed most of the questions coming in, and everybody knows about the legal hotline now. So, Colette, do you have any final thoughts about contracts?
Well, contracts is one of my favorite subjects. So, like I said, if anybody has any questions, please do give us a call. The hotline is there for you as a member benefit to answer your questions. If we can, we will do our best to do that. Take a contracts class, CE class. We all teach that as well. Again, if you've got any questions, shoot them to us over the hotline. And we thank you for taking time out of your schedule to be here with us today. We appreciate you being here. So thank you.
Thank you, everyone, and have a great day.